Hello friends, welcome to Insights ICANN Initiative. In today's video, we are going to discuss about a topic that is sedition, section 124A of IPC. So before we discuss further about this particular issue, first we'll see the syllabus mapping as well as the video components. First, the syllabus mapping is related to General Studies Paper 2. This particular topic in the General Studies Paper 2, it is related to Indian Constitution, features and significant provisions. The video components. In this particular video, we are going to cover why this particular issue is in news, why in news. Then historical background of sedition law, how it came into existence during from the Britishers' time, since the Britishers' time and the modern India also. And some of the opinions from the Jawaharlal Nehru and Mahatma Gandhi ji, some of the popular opinions we discuss on the sedition. Then we discuss about what is the opinion of the Law Commission. What are the suggestions from the Law Commission regarding the sedition, whether it is to be continued or not. So what Law Commission was suggesting, argument as well as against to both. And sedition in other countries, how other countries are implementing the sedition laws. The interesting thing is, actually the Britishers who introduced sedition in India, now they repealed the sedition laws. Okay, and in America also very rarely they are using. And finally we will discuss about the way forward. So these are the video components regarding the sedition. Okay, first tell me students, sedition. Sedition is all about related to which article of the fundamental rights? Tell me. Sedition is related to which article of the fundamental rights? Either directly or indirectly. Tell me. So now the context. First we will discuss. Supreme Court recently, while they are dealing the petitions regarding the challenging of sedition, Supreme Court referred all these petitions related to sedition, referred them to larger constitutional bench. So here you have to understand sedition is present in IPC under section 124A. Under section 124A, sedition. That you have to understand. And now all the cases on the sedition referred by the Supreme Court to constitutional bench. That you have to get it. Constitutional bench means minimum judges strength. Minimum judges strength. What is the minimum judges strength of the constitutional bench? Minimum judges strength is 5. Actually government is arguing that anyhow we are going to replace IPC with like Bharati, Shiksha Samhita, Bharati Shiksha Samhita, and Bharati Nagarik Shiksha Samhita. So we are going to replace anyhow. So what is the point of discussing the IPC? But Supreme Court was saying that even though you are going to bring some new laws instead of the IPC, it doesn't matter. So that law will applicable from then to future, but not to now. So now we are having IPC and we are dealing the IPC, section 124A cases. That is the reason Supreme Court took up these cases. Students, you have to understand Article 20 deals this. Article 20 deals that criminal laws are always applicable to future but not applicable to past. That is popularly known as ex post facto legislation. Ex post facto legislation. That means criminal laws are always applicable to future but not past, whereas civil laws applicable to past also. That you have to remember, students. Next, now let us see the historical background of sedition law, how the sedition law evolved over the period of time from the Britishers' time. Let's see who introduced this sedition law. Thomas Macaulay, 1837. Actually IPC, he drafted the IPC. That Macaulay was the 4th member who was appointed in the Governor General Executive Council. And he was the first chairman of the Law Commission of the colonial India also. He introduced the IPC in 1870. Later, the IPC was amended by James Stephen and he introduced the sedition law. That means the section 124A was not there in the IPC originally. That is the reason it was carrying alphabet A. I told you so many times, any article or any section, if it is carrying alphabet letter I mean, like if it is succeeded with alphabet, like Article 21A, Article 51A, that means they were added later. They were not there originally. People like, very popular people like Balagangadhar Tilak, Mahatma Gandhi and Bhagat Singh, Jawaharlal Nehru, and so many people, they are the victims of this sedition law. They were being arrested at different point of time, and Mahatma Gandhi called this section 124A as a prince among the political section designed to suppress the liberty of citizens. Okay, it was suppressing the liberty of Indian. Jawaharlal Nehru described it as a obnoxious and highly objectionable. The first case filed against Indian J.C. Bose, who was the editor of Bango Basi, who criticized the Age of Consent Bill of 1891. So whoever, even though they are constructively criticized the British government, they were subjected to the sedition. Actually, what is the meaning of sedition? Sedition means either in the written way or in the image pictorial way or through slogans, in any form. If you are inciting violence against the state, or if you are provoking people to act against the state, that is known as sedition. The highest punishment for sedition is death penalty and life imprisonment. And when the person is arrested under sedition, that is a non-bailable offence, and they cannot apply it for any government jobs also if they are subjected to sedition. In this table, we can look some of offences against the state. Section 121A, conspiracy to commit offences, and section 124A, sedition, and 123, waging war against the state, and 153A, promotion of enmity between different groups. So whatever the sections displaying here, all these sections in the IPC, they are dealing with crimes against the state. Next, section 124A, like I mentioned earlier, through words or through written statements, signs, in any form, if it is causing incitement or if it is causing violence against the state, dissatisfaction towards the state, then it is known as sedition. Some of the important cases on sedition: Tara Singh versus the state. It was the first time in the independent India courts look after the, examined the section 124A. Next, Kedarnath Singh case. Here, it was the most prominent judgment of the Supreme Court on the sedition. In 2018, Law Commission opinion on the sedition. In 2018, Law Commission recommended that the section 124A, it should be used only in the exceptional condition, it should not be misused. And section 124A, it must be remain. But the word sedition, it can be replaced with other words. So in 2018, Law Commission clearly mentioned that the sedition, the penalty or the punishment under sedition, it has to be continued. Even though there are some strict laws or alternative laws are there, still we require the sedition has to be continued in the best interest of the security of the nation. Next, as we discussed Law Commission multiple number of times, we will go through the Law Commission also. So Law Commission is a non-statutory body, and it was established in 1955. General Law Commission established for every 3 years. The first Law Commission in the British time, it was led by Macaulay. In the independent India, the first Law Commission was led by the MC Sethalwaj, and is only advisory body which works under the Ministry of Justice. The composition of Law Commission: chairman plus 4 members, including the member secretary and the ex officio member. These ex officio members are from law and legislative secretaries in the law ministry. It will also have not more than 5 part-time members. Generally, either a retired Supreme Court judge or the Chief Justice of High Court, they will lead the Law Commission. The one thing you have to remember, Law Commission advices are always advisory in nature. They cannot be enforced upon the governments. Let's see important recommendations of the Law Commission in the recent days. Law Commission in its 262nd report, it clearly recommended the abolition of the death penalty except in the terrorism related cases. So only in the terrorist kind of cases, person should get the death penalty. In the rest other cases, death penalty should not be given to the individual. Next, electoral reforms 1999. It given a report about that simultaneous elections will improve the governance as well as the stability. Then regarding the Criminal Procedure Identification Act 2022, which replaced the Identification of Prisoners Act 1920, it was also proposed by the Law Commission of India. Like, what kind of details we have to collect from the, like convicted people. Next, the 21st Law Commission, even it recommended the Uniform Civil Code is not required at this moment. This was the 21st Law Commission view regarding the UCC. So those are some of the observations about Law Commission reports. Now let's see arguments in favor of the sedition law. Why the sedition law is required. Then criticism on sedition law. First, let's see why sedition law is required. Let's see. This law deals with the anti-national elements, and anyone, whoever doing contempt of court, they can be punished under sedition. And country like India, which is having Maoist threats and terrorist threats, so in these conditions, we require a very strict law such as sedition. Criticism. The criticism is mainly, this was introduced by the Britisher, and now the Britishers themselves, they are not following this sedition law. That you have to know. They removed, and we are having some alternative laws such as Unlawful Activities Prevention Act. So tell me students, what is your opinion? Do we require sedition, or because already we are having laws such as UAPA and National Security Act? Because of that, do we require the sedition law or not? Answer. And already India is a signatory to International Covenant on Civil and Political Rights. This covenant, this agreement or law, it is completely against the laws such as sedition. So India should re-examine whether to go with sedition or not. Those are arguments against the sedition. Next, sedition laws in other countries. In countries like Saudi Arabia, Malaysia, Iran, Sudan, Senegal, those are the only few countries they are considering sedition still as a criminal act. In UK, like I said earlier, even though the Britishers introduced sedition into the IPC, now the UK abolished the sedition. They are no longer following the sedition law. And USA, section 2385 of the US code, they enforce sedition only in the case of treason, sedition and subversive activities. They use very rarely. South Korea and Indonesia also abolished the sedition. So there are certain laws in India which facilitate the preventive detention. That means they can allow the authorities to arrest a person before the person committing a crime. You know that under Article 22, detention can be done in two ways: preventive detention, punitive detention. In India, following laws are facilitating the preventive detention. They are AFSPA, Armed Forces Special Powers Act, Armed Forces Special Powers Act, UAPA, Unlawful Activities Prevention Act, NSA, National Security Act. These are the three laws which supports the, preventive detention. So tell me students, under Article 22, which clause talks about the preventive detention? Which clause mainly talks about preventive detention? Now, as we discussed UAPA quite sometimes, let's go through the UAPA. Under UAPA arrests, between 2018 and 2020, arrests around 87%, they were below the 30 years of age. And the highest arrest rate under UAPA, UP, but the most unfortunate situation is the conviction rate under UAPA is very, very low. That means we are arresting so many people, but they are very less number of people they are found guilty. Who can be arrested? Both Indians and foreigners can be arrested. Even it is applicable outside of India. And after till police official, they can take up to 180 days to file a charge sheet. That means up to 6 months they can take that particular persons under their custody. What is the way forward? The way forward is, we have to think very in detail, very careful about the section 124A, and this 124A, while repealing this, we have to maintain the balance between the national security and fundamental rights of the citizens. And even though it is there, it should not be misused. So this is the way forward regarding the sedition. Yesterday's video question: the Central Belt of Silk Road Economic Belt project consists of what? Central portion. It consists of Central Asia and West Asia. Now today's question. Which of the following statements are correct about the Law Commission? Read these two statements and Give your answer. Which of the following is right? Question. Although it's alleged that sedition law has chilling effect on the freedom of speech, it is having chilling effect on the freedom of speech and expression, we still need this law. For what? In order to ensure the national security. Comments. Okay, this is today's mains question. As we reach to the end of this video, let's revise quickly. In this video, we discussed about what is sedition and how the sedition got evolved, that means historical background of sedition. And we discussed about law commission observations in sedition, positive side of the sedition law, negative side of the sedition law, how the international practice is there, and related laws of sedition such as UAPA also we discussed. So this is the detailed analysis regarding the sedition.